Is that mine? Nope, not me. Where's the echo? I think that needs muted. We got everybody muted. Technology is fantastic. All right, we'll try that. That's better. Don't quite understand who would have climbed back behind there to turn the volume on today, but who knows? Technology. All right, committee, we'll start out this afternoon. Do I have any requests for bill introductions today? All right, seeing no bill introductions, we'll move to the next item on the agenda. Everybody should have received minutes from the January 10th, 12th, 17th, and 19th. If everybody's had a chance to review those, I will entertain a motion as it relates to those minutes.
Mr. Chair, I will move to pass the minutes as they have been delivered to us.
All right, do I have a second? Second by Representative Smith. All in favor say aye. Any opposed? All right, that passes unanimously. All right, at the request of a couple of committee members, I have asked Natalie to give us a review over SB 367. We met over this last week in our joint committee and had a lot of conversations over the juvenile justice reform. And so we wanted to see if we couldn't bring people up to speed a little bit more on the changes that were brought about by SB 367 6 or 7 years ago. And so Natalie, I'll go ahead and turn the time over to you when you're ready.
Thank you, Mr. Chairman. As the chairman indicated, I am going to go over the contents of Senate Bill 367. That was a bill that passed in 2016. In 2017 and 2018, there were also a couple pieces of legislation that passed that impacted the juvenile justice system. So I'm going to briefly touch on those as well so you guys can see where you sit right now. So Senate Bill 367 required that a juvenile be delivered to the juvenile's parents or guardians unless there's reason to believe that that's not in the best interest of the child or it would pose a risk to public safety or property. A juvenile cannot be taken from a parent's custody unless a detention risk assessment is done and that assesses the juvenile as detention eligible, or there are grounds to override the results of the detention assessment that's given. A juvenile cannot be taken into custody for violation of a term of probation or placement. And to obtain a warrant to arrest a juvenile, a supervision officer has to set forth that the juvenile has violated a condition of disposition 3 or more times. Oh.
Sorry to interrupt. Everybody, there is a document titled Juvenile Justice Reform that was in your email that she is working through. So I just wanted to make sure everybody was aware of that. Sorry about that.
Oh, no, that's fine. Thanks, Mr. Chairman. So again, in order to get a warrant to arrest a juvenile, that supervision officer has to allege that the juvenile violated a condition of their disposition 3 or more times, and that they pose a significant risk of physical harm to another or damage to property. Each director of a juvenile intake and assessment services must adopt a policy and establish guidelines for immediate intervention. Think of immediate intervention as the juvenile version of diversion. That's what it's called in the juvenile realm. And juveniles have the right to participate in an immediate intervention program. Cumulative detention for a juvenile was limited to a maximum of 45 days over the course of the juvenile's case. And juveniles would be presumed to be juveniles, and that presumption can only be rebutted by a preponderance of the evidence. A juvenile would have to be 14 to be prosecuted as an adult. And extended jurisdiction juvenile prosecution can only be used for juveniles who are charged with an off-grid or a non-drug severity level 1 through 4 person felony. That process is one where you're kind of going through the process as a juvenile and an adult at the same time, so that if you kind of mess up on your juvenile sentence, then that adult sentence can be imposed on you. So that is limited under 367 to the most serious offenses. The Department of Corrections, working with the Supreme Court, was required to adopt a statewide system of structured community-based graduated responses for technical violations of probation, violations of conditional release, and violations of condition of disposition for juveniles. They were also required to develop standards to guide immediate intervention. Probation length limits were imposed. Low and moderate risk offenders who were adjudicated for a misdemeanor and low risk offenders adjudicated for a felony could be placed on probation for up to 6 months. High risk offenders that were adjudicated for a misdemeanor and moderate risk offenders adjudicated for a felony can be placed on probation for up to 9 months. High risk offenders adjudicated for a felony can be placed on probation for up to 12 months. Those probation length limits do not apply to juveniles who are adjudicated for off-grid felonies, rape, aggravated sodomy, or murder in the second degree. The court can extend a term of probation if the juvenile needs time to complete an evidence-based program. Overall case length limits were also imposed for cases. Juveniles adjudicated for a misdemeanor can only remain under court jurisdiction for up to 12 months. Low and moderate risk offenders adjudicated for felonies can only remain under court jurisdiction for up to 15 months. High-risk offenders adjudicated for a felony can remain under court jurisdiction for up to 18 months. The overall case length limits, again, don't apply to those most serious offenders, so they don't apply for off-grid and non-drug severity level 1 through 4 felonies. Supervision levels are supposed to be based on the results of a risk and need assessment. A risk and need assessment is required to be conducted before sentencing. And placement of a juvenile in the custody of the Secretary of Corrections can only happen when the juvenile poses a significant risk of harm to another or damage to property and is otherwise eligible based on the offense that they committed. Juveniles adjudicated for certain sex offenses can be placed in short-term alternative placement in an emergency shelter, therapeutic foster home, or community integration program. Sentence maximums and certain scores needed for placement on the risk and needs assessment were created. So we have the serious offender 1 category. They can be placed for a minimum of 18 months and a maximum of 36 months. Serious offender 2s can be placed for a minimum of 9 months and a maximum of 18 months. Serious offender 3s can be placed for a minimum of 6 months and a maximum of 12 months if they are assessed as high risk. Serious offender 4s can be placed for a minimum of 6 months and a maximum of 12 months if they're assessed high risk. Chronic offender 1s can be placed for a minimum term of 6 months and a maximum term of 12 months if they're assessed as high risk. Those offenders, we call that statute there the placement matrix. It's kind of similar. Scott went over the sentencing grid for adult offenders. That doesn't apply for juveniles. It's a little bit more amorphous. It's not quite as rigid as the sentencing grid. And so this is the statute that talks about how long those juveniles can be placed at the juvenile correctional facility. There is a rebuttable presumption that all offenders in the chronic offender category and offenders between the ages of 10 and 14 in the serious offender 2, 3, and 4 categories would be placed in a youth residential facility instead of the juvenile correctional facility. Starting on January 1st of 2018, the Secretary of Corrections was allowed to contract for no more than 50 non-foster care beds in youth residential facilities. A juvenile cannot be ordered to return to the juvenile correctional facility for a violation of a condition of release. They have to be discharged from the juvenile correctional facility when their overall case length limit has been reached. The Department of Corrections and the Juvenile Justice Oversight Committee were tasked with exploring methods of exchanging confidential data between different parts of the juvenile justice system. And the Juvenile Justice Oversight Committee was created to oversee the implementation of the reforms, which I think you're going to hear from the chair of that committee next. The Kansas Juvenile Justice Improvement Fund was created. The Secretary of Corrections was required to certify the cost savings from the reduction in out-of-home placements of juveniles, and then transfer that money into that newly created fund. And then that fund was to be used for funding the community-based programming that would be available to juvenile offenders as they stay in their home. Prioritization of the money in that fund was to be given to regions that are demonstrating a high rate of out-of-home placements of juvenile offenders. So that is kind of an overview of what you guys passed in Senate Bill 367 in 2016. In 2017, there were a few tweaks made to the reform, and that happened in 2017 Senate Bill number 42. So in that bill, it required a judge to consider and make certain findings when they do remove a juvenile from the home for the first time, and that was done to maintain federal 4E funding. That piece of legislation also removed the requirement for the Secretary for Children and Families to prepare parents for a juvenile's return if that juvenile was in an out-of-home placement at the time of sentencing. So if they already weren't going to be returning home, then they wouldn't have to duplicate that work and do that assessment. Supervision officers were given the ability to request a warrant for a juvenile who had absconded from supervision, and the court would be able to issue that warrant and can extend or modify the terms of probation or impose additional condition of release. And along with that, probation length limits were told during any time that the offender was found to be absconding from supervision. So that time wouldn't count toward their successful completion of probation. Juveniles who are charged with sex offenses were not required to be offered participation in immediate intervention programs, and immediate intervention was also not required to be offered to juveniles who were originally charged with a felony, and then that was later amended down to a misdemeanor. Upon a finding by a trier of fact that a firearm was used in the commission of a felony, then the judge would be able to commit that juvenile to the juvenile correctional facility regardless of how they scored on the risk level. The Juvenile Justice Improvement Fund was transformed into what it is now, which is the evidence-based programs account of the State General Fund, and the Secretary was given the authority to certify those cost savings several times throughout the year instead of having to wait till the end of the year to certify the cost savings and move the money over. In 2018, you guys passed Senate Bill 179, and this bill created the Juvenile Crisis Intervention Centers, which you have a bill to make some tweaks to that as well, which you're hearing later this afternoon. So that bill created those centers to provide short-term observation, assessment, treatment, and case planning for juveniles who are experiencing a mental health crisis. A juvenile would be able to be admitted for not more than 30 days when the head of the center determines that the juvenile is in need of treatment. A qualified mental health professional from a community mental health center has given written authorization for that admission, and there's no other more appropriate treatment that is available. A parent or legal guardian would be able to remove a child from one of those centers at any time. A law enforcement officer can take a child into custody when the officer reasonably believes that the child is experiencing a mental health crisis and is likely to cause harm to self or others, and then they would be able to deliver that child to a juvenile crisis intervention center. When a court determines an order or a temporary order of protected custody is necessary, then the court can place the child into a juvenile crisis intervention center as well. And if a juvenile is taken into law enforcement custody pursuant to the Juvenile Offender Code, and they're determined to not be detention eligible on the juvenile offender side, then the juvenile can be taken to the Juvenile Crisis Intervention Center. And then along with that, the evidence-based programs account was expanded to provide that money can be used for services for juveniles who are experiencing mental health crisis and on the development of these juvenile crisis intervention centers. So that is kind of an overview of some of the juvenile justice stuff you guys have done over the last few years, and I can take any questions about it.
Thank you, Natalie. You summed up a year's worth of work in 10 minutes, so well done. Committee questions for Natalie. Representative Titus.
Thank you, Mr. Chairman. Thank you for the summary, and the memo will be helpful, I'm sure, throughout the year. Natalie, if you were to just summarize the one key that made the system that changed from pre to post 367, what would you point to?
I think that probably, and I'm guessing that Mr. Heimer behind me will have some insight into that too, but I think that the biggest thing is that it reduced the number of kids who are in out-of-home placements. So you either, before Senate Bill 367 passed, you had more juveniles in the juvenile correctional facility, you had some juveniles in youth residential facilities, and then after this legislation, the concept is that juveniles stay in their homes or in the, the home setting, and they're not put in these out-of-home placements.
Very good. Additional questions? All right, seeing none, thank you very much, Natalie. All right, committee, now we'll be pleased to hear from Don Heimer, who is the Assistant District Attorney for Johnson County, as well as the Chairman of the Juvenile Justice Oversight Committee. Mr. Heimer, welcome to committee, and thanks for spending some time with us today.
Thank you. I appreciate the opportunity to address you, Chairman, members of the committee. My name is Don Heimer. I am an Assistant District Attorney in Johnson County. I appreciate the opportunity to address you all on what we do through the Juvenile Justice Oversight Committee. You heard that the Juvenile Justice Oversight Committee was a statutory creation of Senate Bill 367, one of the many aspects of that bill. And specifically, and I'll go into more detail statutorily, but it's just to make sure we are a group to make sure that the policies of Senate Bill 367 are being carried out. I want to give you a little bit of background about me because it kind of impacts how I will testify to you all today. So I've been an Assistant District Attorney for 33 plus years in Johnson County, Kansas. All of those years I've been involved in juvenile justice and or juvenile welfare through the Code for the Care of Children, Child Needed Care. SINC is kind of what you probably hear when people talk about it. I have been serving for approximately 24 years on the Juvenile Law Advisory Committee for the Judicial Council for the state of Kansas. I started on that committee when it started. For about 8 years, I authored the juvenile law chapter for the Kansas Bar Association for the Survey of Law for juvenile law in Kansas. And I've delivered, I was going to say dozens, and then I realized it's really more like scores of CLEs across the state. I say that to point out that I'm old. But also so that you understand that as I'm testifying to you as the chairman of this committee, I also have a lot of experience in this field. And so I'm going to do my best to testify as a chairman of this committee only, but there will be times when my other experience may come in, and I'm trying to walk that fine line between not my personal opinions, but the opinions of our committee and the things that we have worked on and that we have agreed upon to bring to you all. It was interesting. The summary was great. Two things I noted. One of the reasons that you're considering this new House bill is one of the things that was removed from the ability to detain a juvenile. You know, we talked about harm to others, harm to property. Prior to Senate Bill 367, harm to self, or in other words, harm to the offender was included, and that was removed as a part of Senate Bill 367. And so that's just a factual. I'm not commenting on that, but that was one of the things that was changed. And on the immediate intervention, the right is for misdemeanors only and first-time offenses. And some misdemeanors are excluded from that. So with that introduction, oh, I knew I, all right, so is there a PowerPoint somewhere? There we go.
There it is.
Awesome, thank you. And your committee was nice enough to change the date because we sent it in with last year's date. So everyone does that, right? We all put 22 for a long time, but it's really 23. So I appreciate Colette changing that for us. Okay, so what I wanted to talk to you about is what we, what are we? What is the Juvenile Justice Oversight Committee? And I know there's a Juvenile Justice Oversight Committee in a lot of other areas. We are the statutory Juvenile Justice Oversight Committee created by Senate Bill 367. We're statutorily defined, a multidisciplinary team of stakeholders. So there's all different arenas are represented, and I'll go over the representation in a little bit. We are responsible for reviewing information and data to look towards the progress towards those outcomes. And the outcomes were shortening the time juveniles are in the system, reducing the number of children in, and we have kind of, and as in government, it's like people who are in out-of-home placement. So in other words, if you're in detention or if you're removed and go to a group home. As was stated, we closed almost all the group homes. And that's where the lion's share of the savings for the evidence-based fund came from. As the policies continued, we also ended up having fewer and fewer people being placed in the correctional facility, which also reduced the cost and the number of people and juveniles in out-of-home placement. The other thing, the Juvenile Justice Oversight Committee provides policy and funding recommendations. So I know we'll talk a lot about the evidence-based fund and the monies that are there. I think one of the misconceptions is that the Juvenile Justice Oversight Committee determines where that money goes, and that our committee does not. We make recommendations to the Department of Corrections, and I have a flow chart to explain that, and you all probably knew that, but I think within some areas of the juvenile justice world, there's a little confusion on that, so I'll try to clear that up as we go along. I think this mission statement talks about us being data-driven. We want evidence-based practices to be implemented, and then the sustainability of these reforms, which when I talk to you later, that's why we don't want to throw a whole bunch of money all at once, put something in place that we can't sustain over time as a program. So I feel like most mission statements are more aspirational than this. This is just simply, this is exactly what we do. So, next, who are we? So this is the membership of the Juvenile Justice Oversight Committee. You see there we have District Attorney, that's me, serving on that, Assistant District Attorney. But if you look at the representation, you all have the lion's share, which is 4 folks. We have 3 Department of Corrections folks, and that's because they do a lot of the work. They're the ones implementing these policies, for the most part, that are put in place for juvenile justice pursuant to Senate Bill 367. And then judges are also represented with more than one person because they have to do the implementation of this kind of where the rubber meets the road in the courtroom. So we have 19 folks, so 10 people are a quorum. Next, it's like, how do we do it? How do we do what we're supposed to do? So in 2021, remember, we've been in place since the bill was created, or since the bill passed, we were created. So by 2017 or so, we were meeting regularly. And honestly, it took, and I've been on it ever since that time, it took a few years for us to kind of hit our stride, figure out what we were trying to do, the best way to do it. And so in 2021, we started developing subcommittees, which is a data subcommittee to define performance measures. You've probably had some testimony in other arenas where you've heard that statewide our data collection on juvenile justice was not where we wanted it to be, which was a challenge for us to make sure these changes were having the desired impact. I think we've improved as a state in terms of how we are collecting this data, but that still was a challenge, particularly for the early years of our committee. We have a communications committee, which I have chaired that subcommittee before I took over as the chair. And what we try to do in that is we put together an annual report, which is sent to you all and other stakeholders. And additionally, we are trying to do a good job of pushing out to other members of the community and the juvenile justice world what Senate Bill 367 is about, the evidence-based fund, how to try to access those monies and services. And then finally, the reinvestment, they talk about making that recommendation that I shared with you to the Department of Corrections as to how we spend the monies that have been saved and our budget line items for DOC. I will say in the early days of the committee, we did most of our work as a committee of the whole. We would show up and we just try quarterly with 19, 20 people to try to work through things, and it was a little inefficient. It was probably what we had to do for a while till we figured out what we wanted to do. I feel like the structure we have in place now makes us more efficient, and hopefully we're doing a better job of what we've been asked to do. So what do we want to try to accomplish? What's the goal? What's that aspirational thing that we all strive for? It's to monitor, for the Juvenile Justice Oversight Committees, to monitor and collaborate with the juvenile justice system agencies to ensure best practices are followed and justice-involved youth receive appropriate supervision, assistance, and accountability, all with the goal of better outcomes for youth in our communities. So that's our aspirational part. That's not in our mission statement, that's in our purpose. That's what we're trying to do. By the way, anytime you have a question, feel free to just ask, or I'll certainly stand for questions at the end if you would like. So we have a few terms that you probably hear thrown around quite a bit in the juvenile justice world, and particularly with regard to Senate Bill 367. Evidence-based. What is an evidence-based practice? I'm far from very qualified to talk about this, but I've heard it enough to know generally that it means practices, policies, procedures, and programs that are demonstrated by research to produce reduction in the likelihood of reoffending. Those are the type of evidence-based practices we're looking to put in place with juvenile offenders once they enter the system. That's defined also in statute that I mentioned there in the outline. A notice to appear. And this is a little bit misleading because I'm sure none of you have, but if you get a speeding ticket, you will get a notice to appear for court, right? It's a notice to appear. You've started down, you're in the system by the time you get a notice to appear. Likewise, in the adult criminal justice system, maybe at a municipal charge, if you get a notice to appear, oh, I apologize. I'm one off. Okay, so when we look at these terms, notice to appear, those are processed for juveniles differently than adults. Adults, that means you're in the system, you have a case number. For juveniles, the notice to appear is to send you to something like your JIAC, your Juvenile Intake and Assessment Center, to determine what the best path is for you. You may end up going to court, depending on the charge and what the prosecutor decides, but likewise, you may end up getting one of those pre-file, immediate intervention program, we call them IIP resolutions. Still, the nomenclature for most of the people in our communities is still diversion, because that's what we're used to, that's what we hear, but that's really not in the Juvenile Justice Code, it's IIP. Unique to the Juvenile Code is you can have a pre-file IIP, so in other words, you don't get a case number, you do not get into quote-unquote the system, you just have certain tasks that you complete, maybe some community service. If it's a drug-related, like a possession of marijuana case, you'll probably have to get some drug and alcohol counseling, get a drug and alcohol assessment. As long as you follow those conditions, you do not enter into the formal system. Likewise, if it's maybe a little more serious charge or you don't respond to the IIP offer, which it is the choice of the juvenile, they're not mandated to have it, and you end up going to court, and then you're in the court system and you end up with an attorney, then they may apply you for post-file IIP, which looks a lot like a traditional diversion, where you meet with a diversion department, they put together a plan, and the court authorizes a contract of diversion, and your prosecution is stayed if you complete that particular diversion program. So,
Can I interrupt you for
yes,
just
absolutely.
1 second? We do have a question from,
I wonder if you could clarify for us and those of us outside of the system, the difference between a prosecution and adjudication. What?
Very good, yes. Okay, so the way the system starts, I used to do a lot of PTA speeches with this. The system's like a big funnel, and the beginning of the funnel is someone commits a crime at some level, whether serious or not serious at all. For juveniles, let's say they spray painted some stuff on a mailbox. That's going to be reported. So that's the beginning of the funnel. And then if the police can investigate and determine who completed that, that's a narrowing of the funnel because they found out who did it. Some crimes go uncharged. Once they have determined that that crime has been committed and a suspect has been ascertained, they can arrest that individual, take him to JIAC, process him. That's a low-level crime, and they would be eligible for an IIP, so they could be handled pre-file. If it goes to court, they might have the opportunity for a post-file IIP or diversion. Likewise, if they go to court, they can be adjudicated. So adjudication, it means you have been found guilty or you plead guilty to a crime, and for your case number, 23 JV 444, you have been adjudicated guilty of criminal damage to property. If contrasting that to just having a report filed on you that would be in the juvenile justice system of the law enforcement agencies, if you have an IIP, you are not in that court system. You have no case number assigned to your event. Does that make sense?
It does, but I guess the difference I was looking for is between an adjudication and an actual, why they're not prosecuted like an adult would be prosecuted.
Oh, you mean adjudication versus conviction?
There you go.
Okay, very good. So, long ago, even before my time, they decided that juveniles were not going to be convicted, only adults would be convicted. So when you go through the process of, if you've committed a crime and there's a carload of kids and 2 of them are 18 and 2 of them are 16, the 16-year-olds go into the juvenile justice system. If they are found guilty, they are found to be adjudicated a juvenile offender for the crime of criminal damage to property. The 18-year-olds might go to court and they will be found guilty of the crime of criminal damage to property, and that will equal a conviction in their record. When I first started in the early 90s, one of the reasons that distinction was important was if you were a juvenile and say you applied for a job application said, have you been convicted of a crime? And you could say, honestly, no. The people who made those forms sometime in the late 90s kind of became savvy to that and put, have you ever been convicted of a crime or been adjudicated as a juvenile offender, so that now juveniles have to say yes if they have been to that particular question. So the kind of the short answer to your question is I think that distinction, which was created for a good purpose, that purpose has kind of been defeated by our new system of how we do backgrounds on people for jobs and things of that nature. Okay. Our history, as you heard, Senate Bill 367 passed in 2016. The process, the work groups started in 2015. The goals, and I think the answer that was given, kind of what's the gist of the bill by the reviser was very good. The statute talked about what they used to call deeper dives. The idea was to prevent deeper dives into the juvenile justice system, and that we would, for juveniles who committed lesser crimes, they'd have a lesser involvement, and then you would try to transition and make sure those folks who committed more serious crimes and committed a higher public safety risk would receive a bigger touch. So they might lose their liberty, those type things. My view of the way that has gone over the years is the debate isn't that low-level people should have light involvement and high-level people should have high involvement. It's the ones in the middle and where that distinction is drawn, where you have most of your debate. So it's hard for me to believe, but Senate Bill 367 is almost 7 years old, and we've been at this for quite a while. There are fewer youth in custody or fewer youth in out-of-home placement. As I stated, we closed the group homes or the what they call congregate care homes. So that mid-level of offender, which used to occasionally be treated outside the home in a group home, now remain in the community with the services that we've tried to put in place and fund through the monies we saved by closing the group homes. So here are some of the specific tasks that we feel like we in the Juvenile Justice Oversight Committee try to work on. When there are potential changes in the law, we like to be involved in that. And once you all approve a change to juvenile justice, we want to work to implement it, to push that out to the providers, the probation officers, the judges, the defense attorneys, prosecutors. We want to train everybody on this new, whatever the new law is. And that's one of the goals of the Juvenile Justice Oversight Committee. We work with OJA, which oversees the probation officers, and corrections, which oversees some of the other supervising agencies, to try to track recidivism. In other words, once they've committed this crime and we put them through our probation process, do they commit another crime? Or are we lowering recidivism with this system? And we tried. Now that, again, has been super challenging due to the data collection problems we had for many years. Again, that is improving. We work to ensure that all these systems are integrated And if a certain location or district is having a hard time implementing these things, we want to help them to make sure, so that's an accountability piece. We also monitor implementation of training efforts, so we're working to make sure folks are trained. Since I've been here, we've had training for probation officers. They were trained on that YLS, that youth level of services that you were informed about that determines what probation looks like. We have the detention risk assessment instrument, and through our agency, through our committee, we've worked with agencies to provide training for that. There was also, as a part of this bill, work to bring in experts on defense, help the defense lawyers in Kansas to be able to properly and appropriately represent their clients. And we had that come in, and they produced a study. So we continue to review topics, anything related to improving the juvenile justice system. And these are statutory duties that we have that we work on. We meet quarterly as a committee. We try to meet monthly as subcommittees. As you all know, sometimes that happens and sometimes it doesn't, but that's the goal. Maybe that's aspirational. So what are some of the achievements? The number of districts and counties and courtrooms that have immediate intervention programs has greatly increased. We helped implement that detention risk assessment tool, which puts in a bunch of data, spits out a number, and if you're above a number, you're likely to be detained. If you're below that number, you're likely to be released back to your family and into the community. We've had, like I said, the evidence-based programs and trainings that we have helped present. There's 68% fewer youth in the correctional facilities since 2013. Now, remember, the SB 367 didn't take over until 2016, and really implementation was probably the middle of 2017. And one of the things that was brought up at the time that Senate Bill 367 was put in place is numbers were already going down, filings were going down, and people in the correctional facility was going down. The concern at that time, as was stated in the Senate Bill 367 testimony and in the statute, was that the number of filings was going down faster than the percentage of folks in detention. So the people locked up was not decreasing as fast as the general filings, and that was a concern that gave rise to part of the rise for Senate Bill 367. And then additionally, on probation, now a juvenile receives a reward for doing well on their probation, and therefore their probation time period gets shortened, even from those time frames that the revisor shared with you. And you can see kind of some aggregate numbers there of over almost 30,000 days where juveniles were able to earn their way off probation earlier. And that was one of the goals, and that's one of the things we look at.
Mr. Heimer?
Yes.
1 sec. Feel free to take a drink. Representative Heiberger has a question for you. I saw him trying to take a drink earlier, and so give him a second.
It's my understanding you did not have any real staff support until recently. Is that accurate? And if so, has that made a difference in your?
Yes. Thank you. That's a very good question. That is correct. We did not have any staff support at all. Kansas Department of Corrections on the juvenile services side would occasionally, they would give us some support. So that was probably not true. They helped us run the meetings and what have you, but there was no dedicated person to work on that now. Matt Bellinger is that person over, I think he's housed in Department of Corrections and maybe funded through them, but he is devoted to Juvenile Justice Oversight Committee. And that did make a big difference. That was another change that we recommended and asked and it's in the statute that there could be such a person, and then that was funded by Department of Corrections. That's a good question, and the answer is yes, it has been very helpful. So we appreciate that that is available to us now.
All right.
Thank you.
And you're one slide behind, but while we have you address that, committee, are there any other questions at this time?
Certainly am.
All right, we'll let you go ahead and continue.
Thank you. I'll get my slides up. All right, so now So some other achievements, more recent. There has been, I think, a very legitimate concern that I shared even in serving on the committee is, are we spending this money in an appropriate fashion, and are we spending it quote-unquote fast enough? And so last year, there was a utilization of 19 million was utilized overall. The other achievement was we started to get some data back since we've been keeping track. The IIPs, or immediate intervention programs, are proving to be successful at about a 90% rate of those who completed their program in fiscal year '22. And this is kind of a big deal because when you give these juveniles this notice to appear to go to their juvenile intake and assessment center to decide what their needs are and if they need to go to court or not, there's no real enforcement of that. If you don't show up, it's not like court, where if you don't show up, the sheriffs come and get you. This is it is really voluntary, but the juveniles are complying at about an 89% rate, which is good. The other thing I want to talk a little bit now about is kind of the funding, and I have some slides later that'll go into that in more detail. But when this was created, the term, and I'd never heard of it before, but it was from the legislature, so I'm sure it's good, right? It was called a lockbox. The money was supposed to go into a lockbox. And that lockbox was only to be spent on items that reduced children going in to custody and being removed from their home. It couldn't really be used for preventative measures. It had to be used for justice-involved youth. So if you were on the edge of trouble, but you weren't getting any police reports on you and you weren't quote-unquote in the system, we couldn't put a program in place for you. So I think that's been something we've worked on and struggled with a little bit. Also, the crossover youth thing, which you'll hear a lot about probably in the course of your work with juvenile justice, and that's where a child may be involved in the child in need of care side of things, but then also picks up a low-end offense. And so they've kind of got a foot in both camps, a little bit of abuse and neglect, and then a little bit of juvenile offender conduct on their part. All right, so our current initiatives and things we are working on right now is we're trying to work on evidence-based practices. We want new grant opportunities for collaborative programs. We are working, and we heard some testimony before our committee on Friday, which was very fortunate. We had our last meeting on Friday, and we had a mental health person from Elizabeth Layton Center, which is an area just south of the Kansas City metro area, but kind of a rural / on the edge of the metro area, and talked about there are, besides just evidence-based, there are emerging practices, there are other levels of programs. It takes a long time to become an approved evidence-based practice. So there was talk from that individual about the need to expand maybe the definition a little bit so we can do more things with the money. We're working to increase communication and community interaction. We are now trying to send out all of our information about the funding and how to write the grants out through county commissions, more local municipal governments, and things like that, rather than just through the traditional juvenile justice folks, which are usually juvenile corrections advisory boards and things like that within each community. We have and are in the process of sending out a one-page flyer that we're going to publish in local community newsletters about how to apply for the grants, so that if there's someone out there in the community that's not maybe as connected to juvenile justice as a traditional person, maybe they just run a place for kids to gather after school, but they're not into the juvenile justice system that deep, that they would be made aware of these funds and how they could potentially apply. And we also are proposing rolling grants so that it wouldn't be every year. It would be maybe every other year, so that folks don't get the grant, start working on it, and immediately have to start working on writing the next grant. Some additional current initiatives. We have been working at mental health and substance abuse. As I told you, we had Franklin Miami County Mental Health, which is Elizabeth Layton Center, meet with us on the 20th, last Friday, to talk about behavioral health and justice-involved youth. There were recommendations at that time. So I know you're here later to talk about House Bill 2033. We actually reviewed that bill as a group, and our committee voted unanimously to recommend that bill to you. The language there of behavioral health crisis versus mental health crisis, and I guess I'll have full disclosure here. I helped draft that in about 2018, the first time it was ponied up. And so, but the reason for that is you want the opening to be a little bit bigger so we can serve more people. So the example that I always use, that we see a lot in our community, is a young man or woman, but it's usually young men who are worked up. They start acting out somewhat violently in their home. Maybe they push or shove their mom, or maybe they put their fist through the wall. Not that those aren't important, but they're not very serious charges in terms of where they are in our statutes. So when they go through that detention risk assessment, they do not score to be detained. But there's clearly a crisis going on within that family. So when they get to JIAC, the juvenile intake and assessment, and they get that scoring, they score to go home. So when they say they're going home, and mom says, I can't have my 6'2", 180-pound, very upset 16-year-old coming home to me, I can't have him. Well, what does that equal? That equals hands off. You have a child in custody who's now, what do you do with that child? And the answer has been they get thrown over into a system that was never designed to handle them, which is the child needed care system. So when they're in that system, now they're thrown in with folks who are abused and neglected children, which was the true purpose of the Child Need of Care Code. And a thing I call them criminogenic sinks, because they're in the sink system because they committed a crime, which I believe was an unintended consequence of Senate Bill 367 and the detention risk assessment tool. If we expand the definition from mental health crisis to behavioral health crisis, we will capture that very episode, as well as the child who's experimenting with really serious drugs. Now that self-harm is not a reason to keep a child in detention, and I'm not saying it should have been, but now that it's not, you can't do things, quote unquote, for their own protection, right? That was kind of the way, when I started, we looked at things. Well, we'll keep them in, it's for their own good, you know? Every parent has said that, right? So as a system, we used to say that. Senate Bill 367 kind of took that out, so now we need a place for those folks to go. So our committee, as I stated, voted unanimously to have our recommendation be that this would be a good change to the system, even though it impacts kind of a rule that was put in place by Senate Bill 367. So I wanted to bring that up to you because it was just very fortunate timing that the bill came to be discussed, and we had our first quarterly meeting on the 20th. Okay, so what does everyone always talk to me about when I'm at my JCAB meetings? Okay, what about all the money? Where's all the money? What's going on? So the evidence-based program account, one of our tasks is to oversee the reinvestments. And we call it reinvestment because it's the money that we're investing in the youth at the local level instead of investing it when they are removed from the home. So to talk about that fund, I just wanted to share with you again that we as the department, we as the Juvenile Justice Oversight Committee, we make recommendations to the Department of Corrections. And the Department of Corrections then puts it into their budget. So this is the money that was saved from the closing of those group homes and also from the closing of one of the correctional facilities. You know, one of the other things is those group homes we closed might have been someplace that these youth that will now serve, at least on a short-term basis at the crisis center, it might have been someplace they would have gone. So they are kind of interrelated here. So I do think it's a good use of those funds. So one of the questions that I asked of our partners at Department of Corrections was, okay, the Senate Bill 367 had an evidence-based fund. Senate Bill 179 had some funding components to it, $2 million, and then there was a $6 million amount. So I was like, where are those monies? And the answer that I believe, and I'm not the final person on this, but in speaking with our partners at Department of Corrections, it appears that through some other statutes and some other workings within Department of Corrections and the budget process, that $8 million is within the evidence-based fund. That is what I have been told. I can't defend or support that. That's just what I was told.
Within or in addition to?
I was told within.
So it is within the fund balance you're about to share with us?
Yes.
Thank you.
That's what I've been told. Okay. So here's a little flow chart. Actually, here's a little flow chart that tells you, so the allocations of these funds start with an identified need. That's probably going to be vetted through our JJOC reinvestment subcommittee and eventually to the whole JJOC. In other words, this is a worthwhile program. This is worthy of the spending of our funds. Then we make recommendation to DOC. The way I understand it, and this is what DOC could ignore totally our recommendation. Now, that's never happened. They've worked very closely with us, but we just make a recommendation that is up for consideration by the Department of Corrections as they put their budget together. Once they do that, they create a budget that goes to you all for approval and goes through the whole budget process that you're a lot more familiar with than I am.
And I don't mean to interrupt you, but that is not the case. And we've told KDOC that. They have appropriation authority of those funds. They do not have to go through the budget process every year. They don't have to be baked into their budget and then receive legislative approval because the legislative approval already exists for them to expend those funds. So I just want to make sure that you're clear on that, and I will make sure, yet again, the KDOC is clear on that, because that part of the process should not be a hindrance to those funds being used.
Very good. That's just the way it's been explained to me. Believe me, I leave that stuff to you guys. You know it much better than I.
Understood. Thank you.
Okay, and so with that, I guess the bottom line for us is we don't control that, I guess is the point for, and you all know that, but that's kind of where we are at this time. But that's within our process. When a need is presented to us or someone brings forward something that needs to be addressed, it goes through our JJOC subcommittee, which makes a recommendation to our committee of the whole, and if we approve it, we make a recommendation to DOC, and then you guys, they can take it from there, or you guys take it from there. All right. So what have we been spending it on up to now? We've got 22 individual. Another thing I wanted to share with you is as we serve as a statewide committee, there are lots of great practices out there and programs that work really well in my county that has 600,000+ people, but those could not be replicated or would not work because there's not enough people to put in the program, there's not enough professionals to run the program in our rural communities. So a lot of the grants that we were, I think when they put this together, they thought would be local grants. Some of the localities don't have the infrastructure to put in place some of the programs that the larger counties have. So a lot of the dollars are statewide initiatives, and in that way, the smaller communities can just access services that are kind of maintained through the state. And one of the upsides to that is some of these things that we had to be nimble about during COVID have actually helped us to put some of these things in place in the smaller communities because they can do telehealth type work for some of this counseling. So that is kind of the challenging part here. So you will see individual grants, and then there are also state grants that operate, which are not really grants because it's just the state providing the service. So you can see we have a total, and to kind of cut to the chase, 116 evidence-based programs and practices for juvenile offenders throughout the state. And you see, we, even in our bullet point, we're using the old language of including juveniles in mental health crisis. So if we can expand that to behavioral health crisis, we're going to be able to reach many more people. All right. So here's the dollars as they've been explained to me. I'm well outside my wheelhouse talking numbers like this, but this is what's been described to me, is that we have about, as you can see there, about 63.5 million utilized, about almost 17 million. Projected balance for fiscal year 23 is a little shy of 47 million. And then I think of most interest, or what I found most interesting, is this slide, which is a little hard to see, but as it's approximately a plan to have everything expended by 32. And I know that sounds like a really long time, but one of the things is, and if we spend a lot of money on individual programs now that have a lot of flash to them, and they might do great for a year or two, but if they're expensive to maintain, most of the communities will not be able to maintain them without kind of spending this money down over time. So this is the plan, and this is how we have been looking at it over time. So the modification of the lockbox and the reappropriating of some of these things, we believe may not, the lockbox may not be the full spirit of the bill, so that we could reach maybe some things that are kind of prevention and some things that reach maybe children who are more child in need of care before they come into this system. So I think expanding that opening is going to be beneficial. I think this, these crisis centers can be the beginning of that, because it isn't every person that can go to a crisis center has to be justice involved. So we're already going a little outside the norm here, but we feel like it's appropriate, and that's why we're recommending it to you. So kind of our last slide is we're working hard to really work a lot as a collaborative with the juvenile justice system and the child welfare system. They're so interrelated. To put up silos there just does not make sense. See, even though I'm old, I can use the current lingo. Put up silos like that, it just doesn't make sense. And so with that, and that was a long time, and I appreciate very much everyone's attention, I'd stand for any questions.
No, great. I really, really appreciate that. So a couple of questions that I have, and then we'll turn to the committee. You mentioned a 90% successful rate in their programming. Are you guys tracking any of the recidivism?
We are, and recidivism is difficult because it has lots of definitions. So the first thing we did was create our definition of that, and we can get you what we have thus far on that. We have folks tracking it. I don't have it off the top of my head. We are tracking it, and you know, that's difficult. Because it depends, I think largely it depends on when you first come in to the system. And so your recidivism means you've been adjudicated, as we talked about, or convicted, and then you pick up another adjudication. By us kind of front-loading a lot of services pre-adjudication, by the time you get your first adjudication, you've actually probably failed another system has failed. So by that time, you're a little, there are issues there that we weren't able to get the first time. So the likelihood of getting them the second time, I think, goes down. So we might be a little bit of a victim of our own policies in that first adjudication is farther down the line than it used to be. But those numbers are there, and we did work on what recidivism is. The challenge with juveniles, of course, is you're usually pretty young when you pick up the charges. So we have to have a window of how far out we look for the recidivism time frame.
Right.
We can share, I can share all those with you. I think KDOC and Matt have those numbers, and I can try to get those to you with what we have so far.
Yeah, that would just be great information. I'd just be curious about that. I wanted to call to your attention House Bill 2021. I'm sure that's on your radar at this point. I realize you guys may not have another meeting before we hear and work that bill, but would certainly love to have your input on that because that speaks to what you were mentioning, expanding the use of those funds beyond just justice-involved youth.
Yeah, and I'm happy, what I can do is we did put a policy in place that without a meeting, we can send, if you have a specific question for me, if you want to fashion it, I can send it out and get our committee's position on that and provide testimony again if necessary, or just provide you an answer, whatever works best for you.
That would be great. Thank you very much. We'll go ahead and go to other questions. I have one or two more, but committee, do we have any other questions for Mr. Heimer? Representative Carmichael.
Thank you, Mr. Chair. Didn't expect you to get to me so soon. I appreciate your presentation. I'm from Sedgwick County. A couple of years ago, I was sitting at a community meeting on a nice afternoon, listening to the community police officer's presentation, and he informed us that we had a juvenile in the neighborhood who was committing 2 or 3 burglaries of automobiles per day. He'd hit one in the morning, sometimes they'd catch him. He'd be out, according to the officer, before the sun went down, and then he'd probably do one more that night before he started again the next day. And they were up to 50 or 60 cases they tied to this guy. And they explained that the reason for this is because the legislature changed the law about juveniles. We used to be able to lock this kid up, but we can't do that anymore. All we can do is catch and release. And of course, everybody in the room looked at me because I voted for the bill. That wasn't pleasant. How do I respond to that? Or I don't think Mark Bennett's doing a bad job. I'm pretty sure he's doing everything he can. Is there something to be done about repeat, comparatively minor, nonviolent, and it's real major when it's your car? I'm sure you understand all of that. How do I answer those types of criticisms of what we've already done before I start to do something else?
Well, if I were wearing my ordinary hat, I'd be super happy to answer that question. But since you called me here as the chairman of the Juvenile Justice Oversight Committee, what I will tell you is when I testified at the beginning about we all agree on low end should have a low involvement, high end should have a high involvement. The discussion is always where is that line drawn? And there's a lot of people who think multiple auto burglaries at some point becomes a serious matter. And there are people who feel like it doesn't. And so that's the debate. I have my own personal views on that, but that's outside, and I apologize. I'd love to answer the question. I was just called to kind of talk about what the JJOC has approved me to talk about, and that unfortunately is not within that purview.
Can you answer, is this the way the system does work, or am I hearing an anomaly of just one kid who somehow has figured out how to pull it off, so to speak? By the way, he's moved, hopefully to Johnson County, so it'll be your problem.
I'll definitely have involvement with him if that's the case. Or else he'll just be so afraid of me that he will not commit any crimes.
Yeah, it was 1980 when I last worked at the juvenile division of our district attorney's office, so I can't do you any good anymore.
I would like to think that someone committing that volume of crime is unusual in terms of getting out and recommitting at that offense, at that level of activity. Can it happen if you apply and do not have overrides on the Kansas Detention Assessment? In other words, that number that it kicks out when you go to the detention facility, yes, that you could be released on something like an auto burglary, which is a low-level, non-person felony. You could be released kind of time and time again. That could happen, yes.
I don't want to take too much of the committee's time. I look forward to talking to you, though, in the hallway if you have time.
Very good. Thank you.
Thank you. Representative Smith.
Thank you, Mr. Chair. Mine is more of a comment to what we're looking at here, and maybe more so to those who are new to the committee and new to the SB 367. It was new to me in 2017 when I started, and I thought, well, this just passed, but my email box was full of comments from people out in the industry who are saying, what in the world have y'all done to us? Look at what's going on. So what we have now and what you're testifying to today, sir, is I think 7 years of experience that we need to determine, was this an anomaly at the beginning, a hiccup, a transition problem, or are what we are experiencing, is that the new norm? And so therefore, is it 89% effective and we need to go after the 11%? And I think personally, that's what we're looking at. There are some things that have really occurred well in this, but we have decidedly, and probably from last week, the combined committees heard testimony that tell us that holes in the net are a little bigger than we suggested they should be. And we thought we were going to capture some that we aren't capturing. And we should pay attention to that. And I think today's bill is one of those where we're trying to make those holes a little smaller, catch a few more. Are we always going to be able to address every anomaly that we come across? I got a phone call last night, a person in my district who said, what in the world, can you guys not, I'm with the sheriff's officer, can you not come pick this 12-year-old girl up and lock her down? Her dad is scared to death that she's going to create a situation that he is going to be held responsible for, right? And so those situations are still occurring. We still have to address them. And so today's bill and others that are going to come up, please pay attention to it as not something we fixed and they're just anomalies, but rather things that we need to address again.
All right, very good.
And I think that's very accurate, and, you know, our job, and I view my job in being on the Juvenile Justice Oversight Committee, is to try to make the bill as it exists as good, as effective as it can be until you all change it, and then we'll work to make whatever the changes are as effective as possible. And I'm here testifying as it exists now with the one amendment that we have approved as a committee. But yes, I think to think that we were going to have a silver bullet that cured all ails in 2016, it needs to be addressed as it moves along.
Thank you. All right, final question from Representative Risman.
Thank you, Mr. Chairman. Representative Smith kind of hit on it. The other 11%, what happens to those that don't comply?
With coming to the NTA? Well, if you're offered a pre-file IIP, and remember, these are misdemeanors, so this is possession of marijuana, this is criminal damage to property, pushing and shoving matches at school that might get written up as batteries. Those, if you don't show up, we can't offer you an IIP if you're not there to accept it. So in those instances, a lower grade offense may end up going to court. Now, they can still get an IIP, but it would be the court-approved IIP. So now they get a case number and they quote-unquote enter the system versus, because they kind of, by not cooperating, they forego their opportunity to avoid entering into the system. So it's kind of a self-filtering, because odds are, the more functional you are as a family, you know, the whole purpose of IIPs and juvenile law in general, for 85% of the kids in it, they're kids making dumb decisions. And we don't want to do anything other than redirect them, put an appropriate amount of accountability, and redirect them on a path to make better decisions. And so for the folks who don't reply or don't show up, they're kind of tipping their hand as to their level of functionality because they don't show up and answer to this. Even if they show up and say, hey, he didn't do it, we want a trial, that's fine, we file it, and then they can have a trial. But by not showing up, it's kind of pointing out that there's some level, usually, of dysfunction there. And so that 11% is going to end up in court, probably appropriately so. You know, sometimes there's legitimate reasons you don't show up, but it's probably a really small percent.
All right, well, thank you very much, Mr. Heimer. I would, committee, I know we've got to move into our bill hearing here, but if anybody else has any additional questions, I know I have a couple. Feel free to email them over. I'll send them all over to you, and then we can distribute them to the committee.
That'd be very good.
Thank you very much for your time. All right, committee, we'll go ahead and move on to our hearing on House Bill 2033 and open that hearing up and ask Natalie to give us an overview on that bill.
Thank you, Mr. Chairman. House Bill 2033 changes the criteria that would be used to refer and admit juveniles to juvenile crisis intervention centers. I'm going to start with Section 6 of the bill because that's kind of where the substance of the bill is. That section amends KSA 65-536. That's the statute that creates those juvenile crisis intervention centers. Current law in that statute allows juveniles who are experiencing a mental health crisis and are likely to cause harm to themselves or others to be admitted to a juvenile crisis intervention center for short-term observation, assessment, treatment, and case planning. This section is amended to change that reference from a mental health crisis to a behavioral health crisis. And then the section later defines a behavioral health crisis as behavioral and conduct issues that impact the safety or health of a child, members of the child's household or family, or members of the community, including but not limited to non-life-threatening mental health and substance abuse concerns. This section is also amended to add substance abuse-related issues to the list of services that the juveniles can receive in the process of admission to a juvenile crisis intervention center. Section 1 amends KSA 382202. That's the definition section in the Child in Need of Care Code. It just adds that definition of a behavioral health crisis to the definition section. And Section 2 amends KSA 382231. Section 3 amends KSA 382243. Those are the statutes that relate to law enforcement taking children into custody and then the court directing temporary placement of those juveniles. Right now, there's a reference allowing temporary placement in a juvenile crisis intervention center. It references the mental health crisis, and so we're just updating those references to refer to a behavioral health crisis. Section 4 amends KSA 382302. That's the definition section in the Juvenile Justice Code to do the same thing, add a definition of behavioral health crisis. And then Section 5 amends KSA 382330. That's the statute relating to law enforcement taking juveniles into custody under the Juvenile Justice Code, and changes those references from a mental health crisis to a behavioral health crisis. The last section, Section 7, amends KSA 7552-164. That's the statute that creates the evidence-based programs account in the State General Fund. Current law there allows money in that fund to be used for juveniles who are experiencing a mental health crisis, and this would just change that to juveniles who are experiencing a behavioral health crisis. And I can take any questions.
Questions, committee? Representative Titus.
Thank you, Mr. Chairman. Do I read this correctly that behavioral is encompassing of mental health, or is it exclusionary the way it's written?
I think that the definition there does say including but not limited to non-life-threatening mental health and substance abuse concerns. So I believe the intent would be to include mental health crisis, but also allow things that might not be considered a mental health crisis to be included in that definition.
Representative Slingenschiepen.
What is the current juvenile crisis center capacity in Kansas with relation to any changes that are being made here?
I could answer that one because it's 0. Nobody's built one yet. Is that correct, Natalie?
As far as I know, yes, that is correct, Mr.
And I see that we have them listed under juvenile crisis centers in about 5 or 6 different locations, but is that a different beast than what we're talking about?
No, this bill is helping to open the doors. Johnson County wants to open the first one of these. Even though this legislation's been around for 5 years, nobody has been able or put together the programming to access the funding to actually build them. And so this is one of the steps to make sure that they get built and get utilized.
So what are the ones we have in the state that call themselves juvenile crisis centers? What are those?
I don't know that we have any that call themselves those at this point.
Map in here that gives about 5. If you look up juvenile justice crisis centers in Kansas, you'll come up with locations in Parsons, Wyandotte, Johnson, and somewhere else. I'm just curious, is there a terminology overlap here with some other kind of
Great question, Natalie.
There may be, Mr. Chairman. I will have to look to see if there's some other type of licensed facility. The KSA 65-536, that's the statute that authorizes the licensure of these types of facilities. And so I think, what Mr. Chairman referenced there is that we don't currently have any facilities operating under that type of license. There could be some kind of community mental health center out there that calls themselves a crisis center for juveniles, but maybe the conferees might have some more information about that.
Well, yeah, I'd love to, let's talk about that a little bit later. I'd love to see that. Thank you. Any other questions? Yep. Representative Mon.
Thank you, Mr. Chairman. Is there a definition somewhere for behavioral health? Fine.
Mr. Chairman, I'm not sure if there's, I would have to look, I can do a search of the statutes to see if there's a definition of just behavioral health. What this bill proposes to do would be to add a definition of a behavioral health crisis to the areas of law as it relates to juvenile justice, children in need of care. So just for that limited purpose. But I'm not sure if there's a more general definition that applies to other statutes throughout the statute base.
Thank you. I was looking at the proposed bill. I couldn't find any definition other than for behavioral health crisis, but it begs the question, if it's a crisis, you know, anyway, but thank you. You've answered my question.
Thank you. Anything else? All right, seeing none, thank you, Natalie. We'll go ahead and invite Mr. Tim DeWeese, Mental Health Director, Johnson County Community Mental Health Center, to the podium. Welcome to the committee.
Thank you, Chairman. Thank you, Chairman, and thank you for the committee members for allowing me to be here. You all have a copy of my testimony in support of this bill. It's really simple, and then I'll be willing to answer any questions that you have, is that when we look at from a mental health perspective, and I get there's a lot of debate, what's the difference between mental health, behavioral health, and back and forth. And a lot of it, when we start to talk about mental health, it's steeped in stigma. You say mental health, you mean mental illness. And so when we focus on a mental health diagnosis, that narrowly defines that funnel that Mr. Hyman was talking about. By doing this, and we wanted to do this back in 2018, by redefining it from mental health crisis to behavioral crisis, you're not only encompassing the mental health issues, but you're addressing the substance abuse issues and also those issues where a young person may be emotionally deregulated. What I mean by is they're having a fit. They're a little out of control. They're not able to manage their emotions. And that wouldn't typically be seen as a mental health disorder. However, when the police are involved at the family's home and that person the family doesn't want necessarily that person to come back or vice versa, or they do go back and in 24 hours the police are out there again, that creates the problem. And so by doing this, it allows us to be able to better serve our community regardless of what is happening. If the person's in crisis, they need some sort of intervention. And this will allow us to do that similar to what we do on the adult side and provide crisis intervention on the adult side. This will allow us from a behavioral health perspective or mental health perspective. It really is bringing together. So Mr. Hyman talked about the silos of the juvenile justice system, child welfare system, and you can throw in there the mental health system. All three of us working together to meet the needs of the clients of each of our communities. And that's what this change allows us to do.
Thank you. Questions for Mr. DeWeese? All right, seeing none, thank you very much.
Thank you very much.
Next proponent is Rachel Marsh, CEO, Children's Alliance of Kansas. Welcome to the committee, Rachel.
Good afternoon, Chairman Owens and Vice Chair Smith. Again, my name is Rachel Marsh with the Kansas Children's Alliance. I spoke with you for 60 seconds last week, so I'm hoping that maybe I could double that this time. I wanted to just let you know that the Children's Alliance of Kansas, as written in my testimony, is an association of 19 different family and children's service providers, and we see youth who are struggling to stay at home with their parents safely, youth who enter the foster care system, youth who are placed with foster parents, and we support those foster parents, and we also provide services, some of our providers in various residential units, independent living care, and psychiatric residential treatment facilities. What we've heard consistently from our members, as you heard last week, is that there is a gap of youth that are exhibiting pretty severe behaviors when you're the one on the receiving end of those behaviors, feeling scared and threatened. And we see the potential amendment to HB, or not amendment, the HB 33 as an improvement to the Juvenile Crisis Intervention Center bill so that we can make sure we're capturing the spectrum of youth that are very difficult to care for right now, so we can get them into a place where we can assess their needs. And hopefully, if there are services available in the community, we'll have time to get them connected to those services, or time, if it is a mental health issue, to get them into a psychiatric provider. But if it is a behavioral health issue, then how do we look at their substance use needs or their juvenile justice services that they might need? So I just wanted to thank this committee for listening to these issues and considering taking action. We support HB 2033, and I'm happy to stand for questions.
Thank you, Rachel. Committee questions? All right, seeing none, thank you very much. Committee, I would bring to your attention written proponent testimony from Tanya Keys, Deputy Secretary, Kansas Department of Children and Families and Kansas Department of Aging and Disability Services. There was no neutral or opponent testimony. Is there any other testimony from the audience? All right, seeing none, we'll go ahead and close the hearing on House Bill 2033. Committee, go ahead and put this on your radar probably for Wednesday. We'll set an additional agenda to get this one worked on Wednesday. So we'll take care of that. All right. With that in mind, the only thing that I missed was very early on. I wanted to take a moment to introduce Becca Zimmer. Becca, if you would stand up and wave. Becca will be interning with me this year, and so make her feel welcome to the committee, and feel free to provide any wisdom that you might have. She'd love to hear it. So with that in mind, committee, thank you for your time. Thank everybody for coming today, and we'll be adjourned.